Welcome to this sponsor-on video about expert witness fees. It gives me great pleasure to introduce you to Roger Mallow, who is very kindly speaking at the Expert Witness Conference on the 9th of November this year. Roger, welcome and thanks so much for coming. Can you just give us a bit of background about your practice?
Yes, of course, Mark. Well, firstly, thank you for inviting me. My practice really covers three main areas: professional negligence, clinical negligence and costs, and they all interlink in some way. On the cost side, in particular, I do a lot of work recovering costs for solicitors in big clinical negligence cases, that sort of thing. And also I deal with a lot of disputes between solicitors and clients, and occasionally solicitors and their experts that they've instructed.
Well, let's move on to that exciting subject of expert witnesses. Let's start from the basics. Terms and conditions. Why are these important between the expert and the solicitor?
Well, they're important really for two reasons. Firstly, to ensure that the expert gets paid at the end of the case, to make sure that there's clarity as to the hourly rates that he's entitled to be paid, cancellation fees, turnaround of work, all these matters, that there's no dispute about that. But the second, which is perhaps equally important, is to assist the solicitor in making sure that he can recover as much as possible of those experts' fees from any other party that's liable to pay, be that the Legal Services Commission or the other party in contested litigation.
And what's the importance of the terms and conditions in terms of liability and contract now that we have Jones and Caney?
Well, it's another aspect of the potential liability, the expert potentially liable in negligence, but also, of course, the terms of his agreement with his solicitor may well disclose the scope of the work he's expected to do, the scope of his responsibilities, and therefore may be directly relevant to the question of the scope of his liability.
Now, in terms of the level of fees that are charged at the end, clearly time records are important. Can you explain what is the importance of time records for expert witnesses?
Yes, well, again, there's really the dual aspect. It is, for example, for those experts who work in cases which are publicly funded, it is a requirement of the solicitor's contract with the Legal Services Commission that he puts in his contract with you, the expert, a requirement for you to keep proper time records. So, for example, if you don't do that, then there is a very high risk that the Legal Services Commission will simply disallow some or all of those fees, and the solicitor will then turn to the expert and say, well, you are in breach either of this express term or even arguably an implied term, and therefore I am not going to pay you for what I've not been able to recover. On a general basis, of course, it's a similar position. Increasingly, you need now to persuade cost judges, if matters come to an assessment, not only that the expert has been properly instructed, but that he's used his time properly. And you need the evidence to support that. And again, if the solicitor is unable to recover those fees, perhaps from another party to litigation, then the first thing he's likely to do is to turn to the expert and ask the expert to justify why he should recover them from the solicitor.
And of course it's a useful management tool for the expert to understand how much time he actually spends on the case, perhaps before he quotes on a further case.
Very much so, and again, increasingly, of course, we are seeing experts being required to estimate in advance the time that they're going to spend and the cost they're going to incur. So being able to look back at previous cases where you've recorded time that you've spent, knowing how you manage your time, being able to give an accurate estimate, and then being able to properly monitor and record your time as you go along are all important aspects of ensuring that you get properly paid at the end of the case.
Well, bearing in mind our experts are not lawyers, can you just clarify for them perhaps the contractual relationship between the expert, the solicitor, the client, the Legal Services Board or whoever?
Yes, this is, at least in my experience, a much misunderstood situation. In a Legal Services Commission funded case, the first point, of course, is that you have no contract as an expert with the client, the claimant, the litigant. You have no right of redress against that individual. They cannot be required, for example, to top up your fees if part of them is not recovered. As far as the Legal Services Commission is concerned, again, you have no contract with the Legal Services Commission. The Legal Services Commission, in fact, is quite blunt in some of its guidance about this, that it really washes its hands of the position and that your rights and responsibilities rest with the solicitor. So it's there that your contract is. Your contract is with the solicitor. If, for whatever reason, you agree terms with the solicitor which are different to the terms that the Legal Services Commission is prepared to meet, then your right to recover the difference between those is between you and the solicitor.
Well, I'm sure you'll deal with these at the conference, but some experts have written into me asking specific questions. Can experts say no to accepting instructions?
Well, that's a fairly simple one. The short answer really is yes. There's no cab rank rule which applies as far as experts are concerned. So, fresh case, fresh instructions, they're perfectly entitled to say no, I'm too busy, or I don't want to take that case.
And supposing an expert witness sends the instructing solicitor their standard terms and conditions, and the solicitor says, I want to change those, what's the expert's position there?
Well, again, this comes down to the fact that the agreement between the solicitor and the expert is like any other contract, it's like any other business, and ultimately subject to one or two limitations which arise because of the expert's overriding duty to the court. It's for the expert to negotiate with the solicitor whatever terms he considers appropriate for him. There's certainly no restriction on the expert negotiating his hourly rates or the times for turnaround for work or times for payment. But of course it's a negotiating process, and you have to come to some agreement with the solicitor.
So if the solicitor is particularly obdurate and wants to change them, but come back to the point that you made earlier, the expert can always say no.
Indeed, the expert's ultimate right in all of this is to withdraw his labour, in effect, is to refuse to take the instructions.
Point one another expert's made is, what's the legal position when the Legal Services Commission or the client has paid the expert's disbursement to the solicitor, but then the solicitor doesn't pay the expert or delays payment?
Well, again, this really comes back to the point that we were discussing a few moments ago. The expert's remedies are against the solicitor. Although there is some talk at the moment of a pilot scheme being introduced whereby the Legal Services Commission will pay experts' disbursements directly to the expert in certain situations. That's not the position at the moment. And the Legal Services Commission's rights and remedies are between them and the solicitor, and the experts are between him and the solicitor. So if the solicitor has been paid money to which the expert's entitled, it's for the expert to pursue that, and ultimately his right is to bring a claim against the solicitor should it be necessary to do so.
And so presumably that's the same advice if whether the solicitor's been paid or not. If the solicitor refuses to pay the expert still has a right against a claim against the solicitor.
Exactly so. Of course, if an expert finds themselves in that position, then they need to think carefully about why the solicitor hasn't been given the funds, and if there's been an issue where a judge has perhaps looked at matters on a between the parties basis in contested litigation and has for some reason disallowed the expert's fees, then the expert needs to think very carefully as to whether or not he bears any responsibility for that before he pursues the solicitor. But ultimately his remedy is to pursue the solicitor.
Another expert's written in, says many letters of instruction have a paragraph something like, please confirm your agreement that should either the court or the LSC downwardly vary your invoice in the matter, upon detailed assessment you will reimburse the difference between the amount of the original invoice and the amount assessed by the court or Legal Services Commission. What should the expert do there?
A couple of possibilities. First of all, it's up to the expert whether or not he is prepared to agree to that term. Although, of course, it is quite a common term, and I know that a number of standard contracts used by various organisations, solicitors' organisations, have a similar term to that. If he does agree that term, then that's probably a perfectly permissible term, subject to one qualification, which is that if the effect of the term really is that the expert is saying that if a judge or the Legal Services Commission say my fees are unreasonable, I will simply accept the reasonable figure, that's probably fine. But what an expert must always be very careful to do is not put himself in a position where his fee is seen to be determined by the outcome of the litigation or the potential outcome of the litigation.
So they've got no vested personal interest in the result
Exactly.
of the trial,
Exactly.
litigation. Yeah.
It is, if it's in effect an in advance waiver on the basis that if my fee is seen as being a bit too high, I will take the lower figure. That's probably fine if the expert is prepared to agree to that, and he doesn't have to.
It doesn't have to. Fine. This is becoming increasingly difficult for experts when the law firm actually gets into financial difficulties. So the expert's done the work, perhaps substantial work, and then the law firm goes bust. What's the situation there in terms of the administration pot?
Well, again, I'm afraid it comes back to the position that the expert is in no better nor worse position than any other creditor of the solicitor.
Mm-hmm.
There is, as I mentioned before, for example, in a public funded case, there's no right for the expert to say, oh, well, this was done under a public funded certificate, therefore will the LSC please step in and fill the void. So if you're working for a solicitor and you're worried about their financial good health, then it's for you to watch out and take appropriate steps.
So perhaps a bit of due diligence on the part of the expert prior to accepting instructions?
Very much so. If you have reasons for suspicion, or if it's a firm that you've never heard of and a quick type into Google doesn't come up with anything that reassures you, then perhaps you need to look a bit closer.
So just say no?
Just say no occasionally.
Now, experts in previous conferences have raised some of these points. Can experts refuse to send the report to the solicitor or refuse to attend court unless they receive payment first?
Well, again, this really comes back to the fact that the importance of terms and conditions, as you were talking about at the start. In my experience, it is extremely rare to have terms and conditions with an expert whereby the expert is entitled to payment in advance. There's no reason in principle why that couldn't happen, but it's extremely rare. If you don't have such a term, therefore your entitlement, unless it's spelt out, will be to payment within a reasonable time. And therefore, if you act precipitately, for example, by refusing to undertake work or refusing to attend court without payment in advance, an expert could easily put themselves in breach of their contract with the solicitor, which could in turn expose them to a risk of non-payment for any work they may have done, or indeed ultimately to a risk of damages either in relation to the claim generally or for any loss that the solicitor might have suffered as a result.
Another suggestion experts have come up with is withhold a current expert's report from a solicitor who owes money from a previous case. I guess it's the same principles.
Again, it's the same principles. Your first port of call is your terms and conditions, which goes back to the importance of those. Again, my general experience is that in most cases what you have is a set of instructions per case. And therefore, if you agree to accept a set of instructions, that will be on the basis that you're entitled to reasonable payment in a reasonable time for the work you do on that case. So again, you have to be very careful before refusing to do work in relation to that case because of some issue beyond the parameters of that particular case.
A final question, Roger. And this is a big complaint for many experts, is they spent a lot of work on the case, they cleared their diaries, they turn up to court, counsel says, thanks very much for coming, but the case is settled. What's the situation there in terms of the fees?
Yes, well, I mean, that is increasingly a difficult position. As I'm sure you know, Mark, the Legal Services Commission towards the end of last year changed their own provisions such that they now simply will not pay cancellation fees where notice of cancellation is given at least 72 hours in advance, and many experts expect or provide in their agreements that their cancellation period is much longer than that. The prime focus again has to be your terms and conditions. It is important that you have something in your terms and conditions dealing not only with what the cancellation period is, but also what you're entitled to in that situation. In the first place, if you have such a provision, then you can look to the solicitor to pay it. Solicitors are increasingly struggling, however, both with the Legal Services Commission and with cost judges on assessments where costs are between the parties, to recover either cancellation fees where the expert, for example, claims the full daily rate for every day of that trial that would have taken place, or where there is a lengthy cancellation period. So an astute solicitor will try to be very restrictive in the agreement that he comes to with the expert as to what is payable. But again, ultimately we come back to the importance of your first question. If it is in your terms and conditions, your agreement is with the solicitor, and whatever problems they may have, if they've agreed to it, you are entitled to be paid it.
Because the express term
Exactly.
deals with it. Well, Roger, I'm really grateful to you. Very much looking forward to the conference in November. So thank you very much for watching. We look forward to seeing you on the 9th of November. Thank you very much.